At the conclusion of this lecture, you will understand the meaning of causality and remoteness of damage, understand the various defenses to actions of negligence, and be able to apply the duty of care principles to auditors and accountants. We have already discussed briefly in the previous presentation the issue of causation and remoteness for breach of duty. We will now examine them in more detail. To demonstrate causation in tort law, the plaintiff must establish that the loss they have suffered was caused by the defendant. In most cases, a simple application of the but-for test will resolve the question of causation in tort law. This is, but for the defendant's actions, would the plaintiff have suffered the loss? If yes, the defendant is not liable. If no, the defendant is liable. Causation may be problematic where there exists more than one possible cause. Various formulations have evolved to ease the burden of proving causation in such situations. An example of a signal cause can be seen in the case of Barnett v. Chelsea and Kensington HMC. Here, a doctor in a hospital casualty department sent a patient home without treating him, telling him to go and see his own doctor. The patient subsequently died from arsenic poisoning. While it was held that the doctor had been negligent in not examining the patient, the evidence indicated that he would have died anyway. Consequently, the doctor's conduct did not cause his death, and he could not be held liable under the tort of negligence. See also the case of Chester v. Afshar. In relation to the but-for test, difficulties have arisen where there has been a number of potential causes of the injury or loss. In such a situation, the onus is on the plaintiff to show that the defendant's breach was the material contributory cause of his or her injury. The case of Performance Cars Limited v. Abraham is a useful example here. Here, the appellant hit the claimant's car, a Silver Cloud Rolls-Royce, as a result of his admitted breach of duty. 2 weeks prior to this incident, the Rolls-Royce had been in a previous accident, whereby another negligent driver had hit the car. As a result of the previous incident, the car required a respray. The claimant claimed £75 for the respray for the prior incident and obtained judgment by default. However, the claimant has never received the sum. The claimant sought to claim the £75 from the appellant, but it was conceded that the claimant could not recover the same loss twice. The question for the court was which defendant should pay, or whether they should be jointly liable. Held by the courts, the first defendant was responsible for the whole amount. The appellant was, therefore, absolved from all liability. Where there exist 2 or more causes which operate concurrently, it may be factually impossible to determine which one was the cause. This has proved problematic, not least because it is the plaintiff's responsibility to establish which one was the cause. On general principles, the burden of proving this is on the balance of probabilities. This means the plaintiff has to demonstrate that there is more than a 50% likelihood of the cause being the breach of duty of the defendant. See the case of McGee v. National Coal Board for a practical understanding on how the courts deal with concurrent causes. Where there is a break in the chain of causation, the defendant will not be liable for damage caused after the break. This break in the chain is caused by an intervening act, and the law recognizes that such acts fall into 3 categories as follows: natural event, act of a third party, or act of the plaintiff. A natural event does not automatically break the chain of causation. If the defendant's breach has placed the claimant in a position where the natural event can add to that damage, the chain will not be broken unless the natural event is completely unforeseeable. See the case of Karslogi Steamship Company Limited v. Royal Norwegian Government. A novus actus interveniens is where there is a new intervening act. This may break the chain of causation, removing liability from the defendant. The legal test applicable will depend upon whether the new act was that of a third party or an act of the plaintiff. Where the new act is of a third party, the test is whether the act was foreseeable. If the act of the third party was foreseeable, the defendant remains liable and the chain of causation remains intact. If the act of the third party is not foreseeable, this will break the chain of causation, and the defendant is not liable for the actions of the third party. See the case of Lamb v. Camden, LBC. Where the new intervening act is that of the plaintiff, the test is whether the plaintiff acted reasonably in the circumstances. If the plaintiff's actions are deemed reasonable, the chain of causation remains intact, and the defendant is liable for the actions of the plaintiff. If, however, the claimant's actions are unreasonable in the circumstances, the chain of causation is broken, and the defendant is not liable for the actions of the claimant. See the case of McHugh v. Holland, Hannon and Kubitz. The position in negligence is that the person ultimately liable in damages is only responsible to the extent that the loss sustained was considered not to be too remote. The test for remoteness was established in the Wagon Mound, 1961. The defendants negligently allowed furnace oil to spill from a ship into Sydney Harbour, which subsequently caused a fire which spread to and damaged the plaintiff's wharf. Although the defendants were held to be in breach of their duty of care, they were only liable for the damage caused to the wharf and slipway through the fouling of the oil. They were not liable for the damage caused by fire, because damage by fire was at the time unforeseeable. The oil had a high ignition point, and it could not be foreseen that it would ignite on water. The test of reasonable foresight, arising out of the Wagon Mound, clearly takes into account such things as scientific knowledge at the time of the negligent act. The question to be asked in determining the extent of liability is the damage of such a kind as the reasonable should have foreseen? This does not mean that the defendant should have foreseen precisely the sequence or nature of the events. This is illustrated in the case of Hughes v. Lord Advocate, where employees of the post office who were working down a manhole left it without a cover, but with a tent over it and lamps around it. A child picked up a lamp and went into the tent. He tripped over the lamp, knocking it into the hole. An explosion occurred and the child was burned. The risk of the child being burned by the lamp was foreseeable. However, the vaporization of the paraffin in the lamp and its ignition were not foreseeable. It was held that the defendants were liable for the injury to the plaintiff. It was foreseeable that the child might be burned, and it was immaterial that neither the extent of his injury nor the precise chain of events leading to it was foreseeable. There are a number of defences in tort for negligence, and they are Volenti non fit injuria, Contributory Negligence, ex turpi Causa, and limitation. We will now examine them in turn. Volenti non fit injuria is a defence of limited application in tort law. A direct translation of the Latin phrase volenti non fit injuria is, to one who volunteers, no harm is done. Where the defence of volenti applies, it operates as a complete defence, absolving the defendant of all liability. The defence of volenti non fit injuria requires a freely entered and voluntary agreement by the plaintiff, in full knowledge of the circumstances, to absolve the defendant of all legal consequences of their actions. The requirements of the defence are a voluntary agreement made in full knowledge of the nature and extent of the risk. At common law, contributory negligence acted as a complete defence. However, under the Law Reform Act 1945, contributory negligence operates as a partial defence, whereby the courts can apportion loss between the parties. This makes it a more attractive option to the courts than other defences, which can operate harshly and absolve a defendant of liability no matter how much at fault they may be. Contributory negligence will often succeed where other defences fail. See the case of Revel v. Newbury. Requirements of contributory negligence. The burden of proof is on the defendant to demonstrate that the claimant failed to take proper care in the circumstances for their own safety, that the failure to take care was a contributory cause of the damage suffered. The Latin maxim ex turpi causa non oritur actio refers to the fact that no action may be founded on illegal or immoral conduct. This maxim applies not only to tort law, but also to contract, restitution, property, and trusts. Where the maxim of ex turpi causa is successfully applied, it acts as a complete bar on recovery. It is often referred to as the illegality defense, although it extends beyond illegal conduct to immoral conduct. It is also questionable whether ex turpi causa operates as a defense or simply denies the existence of a duty of care or other cause of action. The ex turpi causa principle is very much based on public policy, and no clear legal principles have emerged. The defense of limitation is very much based on statute law. The relevant facts here are the Limitation Act 1980 Part 1 and the Limitation Act 1980 Parts 2 and 3. Whilst there is a contractual relationship between an auditor and his client, the company, as a legal entity on which the client's company can sue, the contentious legal area arises in respect of other people who may rely on reports made or advice given in a non-contractual capacity. Indeed, in many situations, the potential plaintiff may be unknown to the accountant. Although it is apparent that the law of negligence allows individuals in non-contractual relationships to sue for damages sustained as a result of the negligent behavior of another party. The success of any such action in relation to company auditors appears to depend on the purpose for which the reports are made or accounts prepared and on establishing a duty of care between the auditor and the person making the claim in negligence. The objective test can be variable and may depend on the circumstances of the particular defendant or the situation. For example, an amateur footballer is not expected to meet the standard of a footballer in the first division. See the case of Condon versus Bazzi. If the defendant is a professional, they will be held to the standard of a reasonable person within that profession. This applies also to trainees. See the case of Wilshire versus Essex. Where there is a divided opinion within a profession as to the appropriate cause of action in a particular situation, then a defendant is not to be treated as in breach of duty by following one body of opinion rather than the other. See the case of Bolam versus Friern. The Bolam Test can be summarized in the decision of the learned judge who held, "I myself would prefer to put it this way, that he is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a reasonable body of medical men skilled in that particular art." Putting it the other way around, a man is not negligent if he is acting in accordance with such a practice, merely because there is a body of opinion who would take a contrary view. In conclusion, you will now be aware that damage must be caused by the defendant. The damage must not be too remote. There are a number of defenses in tort for negligence. They are Volenti non fit injuria, Contributory Negligence, ex turpi causa, and limitation. Auditors have a duty of care in both contractual and non-contractual relationships. Negligence will be judged by the professional standard practice.